Copyright disclaimer. Under Title 17 U.S.C. Section 107, allowance is made for fair use for purposes such as criticism, comment, news reporting, teaching, scholarship, and research. Fair use is permitted by copyright statute that might otherwise be infringing nonprofit, educational, or personal use, tips a balance in favor of fair use. Okay, this comes from Taylor and Ring law offices. This is regarding Scientology. Are arbitration contracts upheld in sexual assault cases? By John C. Taylor, August 5th, 2024. In a recent legal case involving the Church of Scientology, David Miscavige, its leader, allegedly, had a judge removed from a lawsuit, like judge shopping, where a woman accused the organization of sexual abuse. By the way, I want to add that her sexual abuse, a lot of it happened when she was a child. So let's clear that up. And coercing children into marriage. It's called forced marriages. The church attempted to leverage an arbitration contract against the case. Oh, also, I want to bring up that the little that I know about arbitration, and all the religions, even the fake ones, use it, is that they force the victim of sexual assault to include children, sex abuse victims, to oftentimes face the perpetrator and others that are, how do you say it, like helping to, they side with the abuser, is what I'm trying to say. Birds of a feather. Wonder what Rinder knows about that. The church attempted to leverage an arbitration contract against the case, but the judge's efforts to block it resulted in his removal. I don't like how they kind of worded that, but you guys know I'm picky. That's because Scientology didn't like that the judge was doing what was lawful to block the arbitration. So I don't even understand how that's legally possible for them to do, and that's why this law firm, these lawyers, are discussing it. This has sparked questions about the validity of arbitration contracts, especially in sexual assault cases. Brief background about what is happening with the case. According to a Law and Crime News report, the plaintiff, Jane Doe, sued the Church of Scientology. She alleges that she was groomed by the organization's recruiter, Gavin Potter, at just 16 years old. The lawsuit states that Potter was deputized, tasked, directed, deployed, and ordered to recruit young boys and girls to join the religious organization's C organization. How many times have we heard, and I've read and discussed about the recruiters that are the women or the young girls? How many times? If they did not obey the rules to get in or remain in, remember how Jenna Miscavige talked about that in her book? They allegedly would be forced to marry. No, Jenna Miscavige didn't talk about this. She just talked about when she wanted to leave the Sea Org. They allegedly would be forced to marry. Sounds illegal, doesn't it? Some of the children mentioned in the lawsuits are as young as 12. Remember, Serge Delmar got sent to the RPF after he was sexually abused. Doe claims that Potter would flirt and use fear tactics to encourage and entice young girls to join the organization. However, it would then turn into abuse. The Church of Scientology denies, they always do, all allegations. Who's that sound like, you guys? And says there were no wrongdoings whatsoever. Who does that sound like, you guys? What is the arbitration contract involved in the case? The arbitration contract signed by Doe in 2002, at the age of 27, waives her right to sue the church. You know what they do as well? I want to bring this up. Especially with the sexually abused women or young girls. When they want to leave Scientology in general, whether they want to leave the Sea Org or they just want to leave Scientology altogether, they don't allow people to leave until they force them to sign all these papers. It's under duress. And that has been talked about as well. Waives her right to sue the church and mandates arbitration. However, concerns over the contract's fairness have been raised, leading to doubts about its enforceability. Highlight that, Scientology. Bam! Mind you of when Rinder wanted clients of the aftermath to sign these non-disclosure agreements. The arbitration contract was intended to be fair to both parties, please. When you're talking about arbitration in general, but not the ones in Scientology. But the judge, who has since been removed, they're like brushing over that. Miscavige, Davy from the fake Space Navy, had a conniption fit and requested that the judge be changed. Every time Scientology doesn't get their way in these lawsuits, Miscavige or whomever else is dealing with it request a change of judge, who has since been removed from the case. I don't know how that's even legal, to be honest. Cited a previous instance where such a contract lacked fairness and was heavily biased. Like the LAPD? Leading to it being declared unconscionable. Facts, man. Facts. The fact that a child that was sexually abused has to face her abusers in an arbitration agreement, which really isn't an agreement. The judge sought to prevent a similar situation in Jane Doe's case by questioning the validity of the arbitration contract. And there's right now there's being laws created to stop this. However, those efforts are now inconsequential with the judge no longer involved in the case. Signing an arbitration contract, like the one Doe signed, means opting for an alternative dispute resolution method instead of going to court. It's exactly what Scientology wants. This entails bypassing the lawsuit process and judicial intervention. Just what they want. Instead, the dispute is brought before an arbitrator. They really need to be more specific here. In an arbitration meeting, who listens to both sides and renders a decision. Well, from what I understand, you guys, what I've read is that when a former Scientologist is filing a lawsuit and they've signed this arbitration agreement, regardless whether it's sex abuse or whatever, they have to go back to Scientology and most often face the person that abused them or abusers of them in the past. Sounds like how LAPD treat their women, doesn't it? Who listens to both sides and renders a decision. In Doe's situation, the church employs its private arbitration system, like I just said, suggesting that the arbitrator likely possesses familiarity with church practices. It doesn't take a lot to understand all that. It keeps the dispute private. Can you imagine the ludicrousness of this? That's why the word used earlier, unconscionable. Exactly. Private between Doe and the church. It is worth mentioning that the Church of Scientology is not the only one that uses these types of contracts. Yeah, I've said that. Catholic Church, Jehovah's Witnesses, Mormons, all of them, to handle disputes. Other religious organizations have used similar methods. What a great way to keep it in-house, especially when you're sexually abusing children, right? Are arbitration contracts legal? Arbitration contracts are legal. As of now, they are. The Federal Arbitration Act is a federal law that ensures the protection of many arbitration contracts as long as they are considered valid, irrevocable, and enforceable. However, while the contracts are generally legal, they may face scrutiny for being one-sided or unjust. Exactly. Courts evaluate procedural and substantive unconscionability, considering factors like coercion during contract formation and fair terms. Exactly. Coercion. If deemed unfair, the contract may not be upheld in court. I think we're going to be seeing a lot more of this, where they're going to be deemed invalid. And I don't think arbitration was meant for sexual abuse cases. If I understand correctly, it was to be used in commercial interests, business interests. For example, in Arnold versus Burger King, an employee filed a claim alleging that she was RAPED by her supervisor during her shift. Although she signed an arbitration contract, the court determined it was overly broad and unconscionable. In addition, the rape fell outside of the scope of the employee's work. Therefore, the contract was unenforceable. Examples of procedural and substantive unconscionability. When the court looks for procedural unconscionability, they evaluate how the contract was developed or created. On the other hand, when looking for substantive unconscionability, they determine whether the contract looks fair. Below, we will review a few procedural and substantive unconscionability examples. Procedural unconscionability. How long the individual had to look over and decide whether to sign the contract. Whether the individual was aware of their rights and what they would be giving up by signing the contract. Whether the other party threatened or forced the individual to sign the contract. Well, you can count all the Scientologists. The former Scientologists were all forced. All of them. whether the individual fully knew or understood how important the contract was. Substantive unconscionability, whether both parties mutually agreed on the contract. Whether one-sided favors exist. Whether there were overwhelming imbalances or unfairness in the obligations or requirements in the contract. How much arbitration would cost the individual. Signs that the evidence or relief that the individual would be able to obtain in public court is much higher. If you have recently been assaulted or abused by a member of a religious organization, Scientologists, listen up, Scientologists, especially all you young girls that are getting RAPED. There's a lot of lawyers that will work with you and help you. Employer or anyone else, the Los Angeles sexual assault lawyers at Taylor and Ring are ready and available to legally assist you. Our team has built a national reputation fighting for survivors. We know and understand how difficult and complex these cases can be. To get help, please call our offices or complete our contact form as soon as possible to schedule a free consultation. And there's John C. Taylor. John C. Taylor is one of the most accomplished and nationally recognized trial lawyers in California. The broad variety of cases he has tried during his career is matched by few attorneys, trying more than 125 cases to verdict, including police shootings and civil rights and sexual abuse, serious personal injury, wrongful death, products liability, insurance, bad faith, and employment. So I will leave a link in the description box. Like and subscribe if you choose. Otherwise, have an amazing day or night, wherever you are. Peace.